Hey everybody, how's it going? My name is Will and welcome to Copper Jacket TV. So I'm guessing there's not too many people that are aware that there's actually a case currently on appeal at the Ninth Circuit challenging California's ban on automatic knives, but there is. It's a case called Knife Rights Inc. v. Bonta, and it's getting a lot of attention right now thanks to a recent decision by the district court who turned the common use and dangerous and unusual test into a sideshow, perverting the standards set forth in Heller and Bruin by Justices Scalia and Thomas. This case specifically challenges California's ban on automatic and switchblade knives with lengths greater than 2 inches. Well, we've got some news regarding this case that's good for anyone that understands that blades are arms and they're protected by the Second Amendment. So let's go ahead and get into it. Now, real quick before we get started, this channel is proudly sponsored by Attorneys on Retainer, who's backed by Attorneys for Freedom, the only law firm in the entire country that does nothing but self-defense cases. So if you're somebody who carries to defend yourself or your loved ones, or maybe you just keep something in your home for your own defense, having that Attorneys on Retainer membership is some of the best peace of mind that you could ever have, because heaven forbid you actually do have to defend yourself. You could be the one that ends up in handcuffs. And if you don't have an AOR membership, you're reaching out to find an attorney, which could cost you a fortune, or you're forced to rely on the public defender's office. If you're an Attorneys on Retainer member and then something happens, you call the number on the back of that card, you speak to an actual attorney giving you instant attorney-client privilege, and they will be there to defend you through the entire process. Now, if you're interested, I'll put a link down below with some discounts as well. You can also use this code right here with that link to save you a little bit of money on both the individual and family plans. Now, I also want to let you know that if you sign up between now and the end of the year 2025, your price will be locked in until the end of 2030. So you will be guaranteed that your price will not go up for the next 5+ years, which is fantastic. Also, I wanted to let you know that AOR is having a conference on February 20th and 21st. It's going to be a ton of fun. There's going to be a range day. There's going to be a conference day. I'm going to be there. Come by and say hi. There's going to be some other creators that you guys know very well that are going to be there also. So make sure that you register for that. I'll put a link both to AOR for your membership and to register for that conference down below. Okay, so let's go ahead and talk about what's going on here. So again, there's a case currently before the Ninth Circuit called Knife Rights Inc. v. Bonta. This is a case that has now been ongoing for years. Court records show that it was originally filed back on March 15th of 2023. Knife Rights Inc. is a grassroots organization that fights for knife rights under the obvious protection of the Second Amendment nationwide, with wins in multiple states affecting everything from carry to restrictions and outright bans. So here's what's going on. California currently has a ban on switchblades and auto knives. Think microtech and alike. Anything that automatically deploys the blade without the need for physical pressure on the blade itself, like some Kershaws, which are considered assisted opening knives. Well, Knife Rights filed a lawsuit against California, claiming that this ban on an entire subset of knives is not consistent with the Second Amendment and should be overturned. So they originally filed in district court. This is all post-Bruin, when the courts have more clear guidance on how they're supposed to treat Second Amendment cases. Both parties in this case requested summary judgment from the court. Well, the district court judge, Judge James E. Simmons, was apparently not the guy we wanted for this case, because in his decision, which granted summary judgment to Bonta and the state of California, he distorted both common use and dangerous unusual tests so that it would fit his agenda to keep the ban alive. In his decision, he claimed that these knives, which by the way are not any different than any other pocket knife other than the way that they deploy, the judge claimed that there really is no 2A argument here, because they are both dangerous and unusual and not in common use for quote-unquote self-defense. I'm telling you, judges love to leave out keywords when it comes to common use and really lean on self-defense as if that's all that the 2A protects. The 2A protects all lawful activities with arms, including civil defense, recreation, and sporting, not just self-defense. The actual language from Heller and Bruin says lawful activities like self-defense. So you can see right there, by removing like self-defense and just leaning on self-defense alone, you can really change the outcome of this case, which is what he did. But either way, using that butchered reading of those two quotes, the judge granted the summary judgment to Bonta in California, saying that these pocket knives are not protected. So we lost that round. Thankfully, they decided to appeal to the Ninth Circuit, who has since asked for amicus briefs from outside parties on both sides. And we have some major groups that have stepped up and as recently as just a couple days ago, filed briefs in support of knife rights. We now have on record supporting the CRPA, the FPC, the 2AF, Second Amendment Law Center, the NRA, and the NSSF supporting this case. Now, on the other hand, it's the typical disarmament groups that are supporting California's ban. A brief has been filed on behalf of California by both Brady and Giffords, proving right there that they will not just stop at guns. They want it all. They clearly want to see you disarmed in whatever way the state will allow. Now, thankfully, because of Trump, the makeup of the Ninth Circuit has been changing, and we've seen some wins at the three-judge panel level. And because this is such a clear infringement, it shouldn't be too hard to get a win here. These are, in fact, in common use. I have several for myself that I use for lawful purposes, like self-defense, but mostly for just opening boxes. So now we wait for oral arguments. But it's exciting to know that California's stupid ban might finally be coming to an end. Who knows? This could be a huge case that eventually heads to SCOTUS, but we'll have to wait and see. But for all you enthusiasts out there like myself who have a nice collection and don't want to see it disappear to tyrants, or you just want the freedom to choose what action you want, this video is for you. Hopefully this all ends well. I want to thank you all very much for watching. I really do appreciate it. Please like, subscribe, and y'all have a great day.